Can statements be suppressed if it's a Miranda violation?
That is another great question, and we would also file a motion to suppress statements, and it's a common defense motion that we use, particularly in the context of interviewing, interrogating our client, and they give incriminating statements. And there are many cases that, but for our client giving the statement, they would not be charged. And what I mean by that is there's no other evidence. The best evidence a police officer could ever have is a confession, saying, I did it. Or, yeah, I was there and I did whatever it is I'm accused of doing. However, they have to obtain those constitutionally. And this is a very frequently misunderstood aspect of law, because a lot of times we get calls at our office and they say, they did not give me my Miranda rights. It doesn't apply in every situation. That's a whole nother probably lecture. However, that is something we are always, as defense lawyers, looking at. If our client provided a confession or incriminated himself or herself, is if they were in custody, and you can be in custody without being in cuffs. Naturally, we think of being in custody as somebody cuffed, somebody's in a jail cell, in an interrogation room. That doesn't necessarily have to be the case. However, if that person is what we deem to be in custody, they have to be Mirandized if the officer is asking guilt-seeking questions.